Hello friends, in the series on the income tax cases, today we will discuss a very important issue in the case of notices which have been issued to the non-resident Indians under section 148A clause B for the simple reason that they have made some investments from their non-resident external accounts. As all we know that whatever the investments which have been done from the NRE accounts, according to section 10 subsection 4, they do not become the part of the taxable income. Since those non-resident Indians are not filing their returns of income and the department has the information about the fixed deposits from the inside portal, so they are issuing the notices to the various non-resident Indians, and in spite of giving their submissions, the notice under section 148 has been issued to them. So what is the fate of these type of notices, and what assessee can take the plea in their assessment proceedings if they have been issued notice under section 148? This case will help them in giving their replies to the notice under section 148A clause B and even in the assessments also. The name of the case is Nitin, Mavji, Vekariya versus Income Tax Officer. This case has been reported in 461 ITR at page number 18. The matter has been decided by Gujarat High Court and the date of the judgment is 11th September 2023. The case relates to the assessment year 18-19. The facts of the case are like this. During the assessment year, the assessee has made an investment of rupees 1.92 crore from his various non-resident external accounts into the various fixed deposits and mutual funds. Since the assessee was not having taxable income in India, so he didn't file the return of income. But from the information from the inside portal, the assessing officer came to know that the assessee has made some investments, but the return of income has not been filed. So he made up his mind that some income has escaped assessment. So he issued the notice under section 148A clause B. The assessee, in response to that notice, submitted his various bank statements related to the non-resident external accounts, copies of FDRs, mutual funds, and his copy of passport which shows that he is a citizen of Republic of Uganda. The plea of the assessee was that these investments, according to the provisions of section 10 subsection 4, do not come into the tax bracket. So the case of the assessee should not be picked for 148 scrutiny purposes. But in spite of the submissions of the assessee, the assessing officer passed the order under section 148A clause D and issued the notice under section 148. The main contention of the revenue in issuing the notice under section 148 was that the revenue is not able to determine the residential status of the assessee from the passport. So he issued the notice under section 148. When the assessee challenged this notice under section 148 into the writ court, the court said that in the present facts and circumstances, after giving the point-wise submission of the questionnaire raised by the learned assessing officer, the assessing officer has miserably failed to appreciate the provisions of section 10 subsection 4. The court said that in the present case, since the investments have been made from the non-resident external account which according to section 10 subsection 4, all these incomes and investments do not come into the bracket of income tax. So the notice issued under section 148 and consequently the order passed under section 148A clause D does not stand valid in the eyes of the law, and the Gujarat High Court quashed the notice under section 148. Friends, this case is very important for all those non-resident Indians who have been issued notice under section 148A clause B on the pretext that they have made some investments from the non-resident external accounts and they have not filed their return. So this is a case of the importance of a milestone. At the end of this video, Once again, I am repeating the name of the case. The name of the case is Nitin Mavji, Vekariya versus Income Tax Officer, and this case has been reported in 461 ITR at page number 18, and the matter has been decided on 11th September 2023. Thank you, friends.